Justice Coordinating Council. I'd like to welcome everyone to the meeting today. Our first agenda item is the minutes for July 14th. Everybody should receive those via email. Does anybody have any corrections or suggestions for changes? Seeing none, can we get a motion to approve the July 14th meeting?
So moved. This is Shay.
Shay, you want to make a motion?
Yes, I would move to approve the minutes.
Do we have a second?
Second, Mike Patrick.
Thank you. All in favor? Raise your hand. Thank you. Majority. The next item is the August 11th meeting minutes. Those should have been received via email. Does anybody have any corrections or suggestions for changes?
I do want to bring something up, which is, do we even have a quorum right now?
Well, let's see. I should know my total voting numbers off the top of my head. We have 10 voting members present. In 1 second here, I'll look up. So we officially have 17 voting members and we have 10 present.
Okay.
So we do have a quorum.
Thank you.
Mike, I don't know if you saw Jennifer's message.
I'm here now.
Oh, good.
Yeah, we got a couple more folks that were stuck over in the other side, so we should have a much fuller quorum now.
Perfect, thank you. All right, going back to the August 11th meeting minutes, did anybody have any suggestions for changes? Everything in the chat, I want to look in the chat box. No. Okay, seeing none, do we have a motion to approve?
So moved.
Jennifer and Amanda made a motion. Do we have a second?
Second.
Lori Alvarado is the second. All those in favor, raise your hand. Perfect, thank you. That carries. And our next item on the agenda is an arrest for failure to appear presentation by Judge Mark Simpson and Dr. Matt Cravens.
All right, well, good morning. My name is Mark Simpson. I'm a district court judge here in Douglas County. And Dr. Cravens and Mike Brower and I have been working on looking at some data regarding arrests for failure to appear. And so I thought I would give you some background information to kind of give you some context to this data. So I'm gonna go first and then Dr. Cravens will go after that. Just as a caveat, you know, anything law related, there's always exceptions and other caveats, but this information is generally how things work. And so my hope is everybody can kind of have a baseline understanding of this area. I know there's a lot of expertise in this group on this topic, but hopefully everybody can kind of have a baseline understanding of what the data means when that's part of the presentation starts. So yeah, if we go to the next slide, please. So there's a variety of ways that people can get into the court system in criminal cases. And regardless of the process for getting there, when we say failure to appear, what we mean is person has a court date in front of a judge and they don't show up. That's what failure to appear means. And when that happens, a judge can decide to issue a warrant for that person's arrest. And then the judge will set the type and amount of bond on the warrant. That warrant then goes to law enforcement, who arrests the person, takes them to the Douglas County Jail, and then either that person makes the appearance bond and is released with a new court date, or they remain in jail because they can't make the bond and they attend because they're in the custody of the sheriff, who then takes them to court. I think it's important to remember as you're looking at this data that criminal cases can't be resolved without the presence of the defendant. So that's unconstitutional. We don't try people in absentia in the United States. So a warrant that's issued after somebody fails to appear is an important tool for getting a person back before the court so that that case can be resolved. Of course, you have to be mindful of the fact that there are many direct and indirect consequences that an arrest has on the life of a defendant and also on their family. So if we go to the next slide, please. So just as sort of basic background, there's 3 types of crimes under Kansas law. There's felonies, misdemeanors, and infractions. And I wanted to point out those different levels of crimes because the seriousness of the underlying crime where a person's charged, and then if they fail to appear, a warrant's issued, that underlying crime and how serious it is a key factor that judges take into account when they're deciding what the bond type and amount should be if somebody fails to appear. I think it's also important to think about the seriousness of the crime charged when you, as the CJCC, are considering the jail population and you're evaluating the extent to which the people who are in jail need to be in jail. So just quickly, felonies are the most serious crime under Kansas law. The felonies are crimes where, with a few exceptions, the sentence can include a prison sentence. So then below that, you have misdemeanors, which is crimes where the sentence can be up to a year in the county jail. And then you have infractions, which are crimes where the penalty is a fine only. Go to the next slide, please. So most cases in Douglas County, criminal cases, are handled in either the district court or Lawrence Municipal Court. Now, both Baldwin City and Eudora have municipal courts, but the number of cases is smaller compared to the district court or municipal court. And I think you should keep in mind that district court and municipal court are different, separate entities, and they handle different types of cases, although there's a little bit of overlap in what the 2 courts handle. Judge Miller, who's on the CJCC, is the municipal court judge. And then Judge McCabery, who's also on the CJCC, is the chief judge for the district court in Douglas County. And in total, there's 6 district court judges and 2 pro tem district court judges. So in every case, there's a judge, and each judge makes their own independent decision in cases based on the facts as they see them and the law. And so in Douglas County, it's important to keep in mind that there's multiple independent judges who are making decisions regarding warrants and setting bonds. Now, I mentioned that the 2 courts handle different types of cases. And if we could go to the next slide, please. So district court handles felony cases, and we're the only court that handles felony cases. We also handle misdemeanors and some infractions. So district court cases, when you're looking at that data, that can include really anything from speeding tickets all the way to murder. And then we also handle appeals from municipal court and a range of other non-criminal cases. If I go to the next slide, please. Then Lawrence Municipal Court handles violations of the Lawrence City Code. And those violations can be either misdemeanors or infractions. So it could be misdemeanors like battery or misdemeanor theft, or infractions like speeding tickets that are issued within the city of Lawrence. Do the next slide, please. So when somebody fails to appear for court, the judge can decide to issue a warrant. And the judge decides the type of the bond, the amount of bond, and any conditions that are on the bond for that warrant. Next slide, please. There's 3 types of bonds. So there's 3 options the judge has. And these are all types of appearance bonds. And all warrants have one of these 3 types of bonds if a bond is set. So they're cash only, cash or surety, or own recognizance. Next slide, please. So looking first at cash only bonds. So cash only bonds require that the person who's been arrested or somebody acting on their behalf, like a family member, to actually deposit with the court the amount of money that's required by the bond. So for example, somebody with a $1,500 cash only bond has to pay $1,500 before they're released from jail on that bond. And the way that works is the money is deposited, the person is released from jail, and they get a new court date. And that money is held by the court to ensure that the person shows back up for their next court date. If the person appears at all of their court dates, then the money goes back to the person who posted the bond after court costs and restitution and some of those things are paid. But if the person fails to appear, then that bond gets forfeited and they lose the money, which is what the incentive is to appear as ordered. So that's cash only bond. Next slide, please. Then you got the cash or surety bond. With a cash or surety bond, the defendant can post the full amount in cash. Or more often what they do is they can contract with a surety that's also commonly known as a bail bondsman or a bail agent. And the surety guarantees the appearance of the defendant in court and is responsible for paying the amount of the bond if the defendant fails to appear and or finding that person and bringing them in to the jail if they fail to appear. So in exchange for the surety guaranteeing their appearance, the defendant has to pay a bondsman a percentage of the bond amount as a fee. That's usually 10% or a minimum of about $150. So as an example, a defendant with a $1,500 cash or surety bond ends up paying a bail bondsman about $150 to get out of jail. Now, at the end of the case, the defendant doesn't get that fee back. It's just payment to the bondsman. But that's less than paying the full amount of the bond as would be required on a cash bond. Next slide, please. And then the last type of bond is the own recognizance bond. And with an own recognizance bond, the defendant who's in jail agrees to pay the amount of the bond if they fail to appear. So they're basically released on a promise to pay, but they don't have to actually post any money up front, and there's no bondsman involved. So as long as the defendant on an own recognizance bond shows up for court, they're not going to have to pay anything. But if they fail to appear, that bond gets forfeited, and then they have to pay the money. So as an example, a $1,500 OR bond, an own recognizance bond, the person gets out of jail on a promise to pay $1,500 if they fail to appear. So those are the 3 types of bonds. If we go to the next slide, please. And it's important also to keep in mind that appearance bonds are authorized and they're controlled by Kansas law. And according to the law, there's 2 purposes for appearance bonds. First is to assure that the person comes to court. And the second purpose is to assure the public safety. And so that's why a judge can include reasonable conditions on the bond. One of the most common conditions on any bond is don't have contact with the alleged victim. So a judge can set reasonable conditions that are related to public safety. Next slide, please. And judges are required to consider certain factors when they're setting bonds and conditions. And I listed the statute there on the slide, and it has a full list of all the considerations. But I've listed some of the factors here. And all those factors are related to making sure the person appears for court and also protecting public safety. So some of the factors that a judge considers when setting a bond type and bond amount is the nature and circumstances of the crime charged. A judge will also consider the defendant's ties to the community, does their family live here? How long have they lived here? Do they have a job? Those are all things related to their motivation to appear back for court as opposed to fleeing and going somewhere else because they have ties to this community. The court will also take into account a defendant's criminal history and prior failures to appear by the defendant. Also, whether the defendant's likely to commit crimes while on release, and whether the defendant is already on probation or parole when they allegedly committed the crime that they're held on. So my point in showing you these factors is that judges aren't just setting bonds based on a whim. There's a statute that tells us what to consider in setting the type and the amount of bond. Okay, the next slide, please. And then one just final point to keep in mind is that anybody who's charged with a crime and held in jail because they can't make their bond is entitled to have the judge review that bond. So if the bond is high and the person can't make it, that person, the defendant, and their attorney can appear in front of the judge and they can make arguments about why the bond should be reduced or changed. So that's something to keep in mind too. The judge doesn't have to do it, but the statute requires that people can address that with the judge if they can't make their bond. So that's just a quick rundown of some of the background information about appearance bonds. It hopefully provides a little bit of context for the data that Dr. Cravens is going to present to you.
Hi, everyone. I hope you can hear me okay. I want to start off by thanking Kyle Appleby and Lieutenant LaRonda Room for being good sources of help on data questions regarding Spillman. So thank you. 21% of bookings into the Douglas County Jail are people booked with only FTAs. It could be one FTA, it could be two or more FTAs, but it's no other types of offenses. Another 3% of people are people with an FTA and a probation violation, and another 8% are people with an FTA and a new offense. So what this means is that 32% of bookings into jail have at least one FTA. This is the most common offense grouping among bookings. The next most common offense grouping is for battery and assault. 15% of bookings have either a battery or assault offense. What this all means basically is that FTAs are a cause for investigation, and we should figure out more about the people arrested for them, what types of cases they have, and what types of bond are ordered for them. So one note, I sometimes refer to FTA as offenses. This is just because the Spillman system categorizes them as offenses, but we typically just refer to them as FTAs. And I also need to point out a caveat about the FTA with probation violation category. So this category doesn't include some people with warrants for FTAs that are because of probation violations. We are reporting what's in the Spillman system, and Spillman doesn't tell us when the originating offense for the FTA is a probation violation. So if we were able to identify and include these people, the FTA with probation violation category would include some additional people in it. Now to a description of the data we're using. These data cover approximately the last 3.5 years of bookings. Specifically, they cover all 16,257 bookings from January 1st, 2017 to July 15th this year. We pull the data from the Spillman Jail Management System. This table shows that people booked into jail with only FTAs stay roughly the same length of time in jail as people with all other non-FTA bookings. You can see that the median days in the FTA only category and the all other bookings columns are both 0.8. At the higher end of the distribution, at the 75th percentile of days in jail, people with FTA only bookings stay longer than people at the 75th percentile of days in jail for all other bookings. By contrast, people booked with an FTA and a probation violation or an FTA and a new offense stay much longer. People with an FTA and a probation violation are staying a median of 22 days, and people with an FTA and a new offense are staying a median of 6 days. People with FTAs make up a somewhat smaller share of the standing jail population than of bookings. For the February 16th, 2020 population, we see that 30% of inmates had at least one FTA they were being held on. Specifically, 13% of people were being held on FTAs only, 5% were being held on an FTA with a probation violation, and 12% were being held on an FTA with a new offense. Fewer people are being held on FTAs in the post-COVID period. Here's a distribution on August 17th, 2020. 7% of inmates were being held on FTAs only on that day, and another 15% were being held on an FTA with a probation violation or an FTA with a new offense. This figure shows the mean number of offenses at booking. You can think of offenses as being kind of like charges, but technically they're offenses at booking which are prior to charging. People booked with FTAs only have an average of 1.5 FTAs at booking. So people coming into the jail with FTAs often have more than one. People with all other bookings have a similar number of offenses, about 1.7. People booked with an FTA and a probation violation or an FTA and a new offense are in a different class. They have an average of 4 offenses at booking. This figure shows the court jurisdiction for jail bookings with FTAs and bookings with other offenses. A majority of all other bookings, 61%, are for district court, 30% are for municipal court. By contrast, for FTA-only bookings, district court is responsible for only 37%, municipal court is responsible for 44%. Another 9% are both district and municipal court. Municipal court is therefore responsible for more bookings with FTAs than district court. This page shows the court jurisdiction and case type for all FTAs at booking. Case type is whether it's a traffic, criminal, or other case. Other primarily includes people who haven't been assigned a case number yet, so new charges, or where charges haven't been filed by the DA's office. One note about these data, they show all FTAs, which is slightly different than all bookings. It's different because there can be multiple FTAs per booking. The figure shows that 27% of FTAs are for municipal court traffic cases, 28% are for municipal court criminal cases, 14% are for district court traffic cases, and 17% are for district court criminal cases. One takeaway from this is that FTAs for traffic offenses, for traffic cases, are bringing about as many people into jail as FTAs for criminal cases. The first row of this table shows that district court judges hardly order cash bond for FTAs or for other offenses. District court only orders cash bond for 10% of FTA only bookings. From the all other bookings column, we see that only 1% of all other bookings have cash bond ordered for them. District court orders cash or surety bonds for about 60% of FTA only bookings, and it orders own recognizance bonds for about 27% of FTA only bookings. In the FTA with probation violation and FTA with new offense categories, we see that people with district court cases have a mix of bond types. Municipal court is primarily responsible for cash bonds for FTAs. Municipal court orders cash bonds for 82% of FTA only bookings, 79% of bookings for an FTA with a probation violation, and 85% of bookings for an FTA with a new offense. Municipal court orders own recognizance bonds for 10% of FTA only bookings. The all other bookings column indicates that only 1% of all other bookings from municipal court have cash bond ordered. 67% have own recognizance bonds. This 67% makes sense because in 2016, Warrants Municipal Court started implementing own recognizance bonds for all people booked into jail with new charges and not arraigned on a prior case. So here are some takeaways from the data. We've seen that FTAs bring a lot of people to the jail. FTA only bookings represent 21% of all bookings. Inmates with only FTAs account for 7 to 13% of the standing jail population. Municipal court accounts for more jail bookings for FTAs than district court. 37% of FTA only bookings are for district court and 44% are for municipal court. In general, FTAs for traffic cases bring about as many people to the jail as FTAs for criminal cases. Finally, judges in Douglas County hardly order cash bond except for with FTAs. Cash bond is used most frequently for FTAs in municipal court. So those are some takeaways from the data, and I will turn it over to Mike for any questions that people might have.
Well, you're welcome to ask questions, but I'm just going to turn that to Judge and Matt. But do people have questions? Tamara has her hand up there. And Tamara, it looks like you're on mute. There you go.
I am, and I did not have my hand up. So I must have done that by accident. Sorry about that.
Oh, I think that's my cursor. Sorry.
No. You just assumed I was going to ask a question, didn't you?
Right?
No, I didn't have a question.
So the FTAs could represent somebody multiple times if they keep failing to appear. Is that right?
I believe that's correct, right, Matt? In that data set, one person could be in there multiple times.
Right, if they have multiple FTAs, that's possible, yes.
Do we know that the cash bonds have any effect on their appearance rate? I mean, do we know that? Or, I mean, do we know if any of those things are actually effective, I guess, is my question.
You know, there's a large range of literature, research literature that talks about that, and I can't say I can summarize that in a sentence or two, or even would know exactly what that literature says, but in terms of Douglas County data, no, we haven't actually determined whether or not the cash bond amounts or cash bond versus a different type of bond have an effect on appearance. I mean, I'm sure there's anecdotes that we can gather about it though, and Judge Simpson may have more thoughts on that.
I don't know that I have anything to add on that. I think that, you know, part of what part of the reason I think we started looking at this is just to get I think people wanted to get a handle on who's in the jail and why. And so that's the most basic thing here, is that, you know, about 21% of the people who are arrested and booked in the jail, they're there for failure to appear. But the data shows they don't stay very long. They stay less than a day, mostly. And then when you look at the jail population as of August, only 7% of the jail is people who only have failure to appear. And so I think that's significant, because when you look at when you look at the people who have failed to appear, but they also have a probation violation, or they failed to appear and they also have a new offense, those are people that are getting arrested probably regardless of the failure to appear. So when I look at this data, the failure to appear only data, I think is the most significant as far as kind of explaining where we are with who's getting booked and who's in the jail.
Thank you.
The other one quick thing I would note on the slide that shows district court cases, traffic cases, district court criminal cases, keep in mind, so 14% of people booked on failure to appear have an underlying traffic case in district court. Keep in mind that in district court, traffic case can mean speeding. It could mean DUI 6th. So there are felonies that are given traffic case numbers in district court. So that, you know, I think sometimes you look at that and say, well, people are getting arrested for traffic cases. Well, the traffic cases in district court, that covers a wide range of offenses, all from infractions, misdemeanors, and felonies.
That's helpful.
Matt, I think one of the most helpful things that you've been bringing to this group, as well as a racial disparities group, is just a wealth of information that has allowed us to kind of continue to ask questions as we hone things forward and really look at where we can have an impact within the system. And I know that you're pulling together so much information. I just wanted to express my gratitude to you and to Mark as well today, Judge Simpson, for all of this, because while I don't think that we're ever going to find, the thing that would fix all the things, this information has been really helpful for us as we navigate through the system. So thank you for that.
Very glad I can be helpful. And again, it's nice that you point out that there aren't going to necessarily be any smoking guns that originate from the data always, but there are definitely pointers about what we might do on the margins that will affect things, and what can help and what can't help. And so I think the data paint a nice picture, and I'm glad that you said that. Thank you, Mayor Ananda.
I guess along those lines, and this is Sarah, so where do we go from here with this? Do we need to break it down into by court? Do we, do members of the CJCC or staff have some thoughts as to how to sort of develop a plan to address these, or to sort of dig either deeper and come up if there are some strategies that might help?
I guess I have a question about what the normal expectations would be. Don't we expect there to be more crimes that are low level? Just in the general population?
Well, I can tell you the last time I looked at the data, the number of cases of the type that municipal court and district court handle concurrently with each other, which would be misdemeanors and infractions. I think the last time I looked at this was 2016 or so. Municipal court had 3 for every one that district court was handling at that time, whereas district court's got all the felonies. We have none of the felonies. So when you're looking at the overall data regarding the percentage of failures to appear, I don't know what, because our case numbers have gone down the last few years. So I don't know what proportion of the actual cases charged those represent or not, but at least historically in general for things like misdemeanors and traffic infractions, municipal court handles way more, a lot more than district court does. So I think, so to answer your question, yes, there are way more, there are far more misdemeanor cases and traffic infractions than there are felonies.
So can we go a step further and say that that is what is getting people, those kinds of problems are what are getting people in jail more often?
Well, from a frequency perspective, sure, more cases of one type mean more opportunities for failures to appear. From an intensity perspective, the answer is no, because obviously people who are charged with felonies, for example, if you get charged with murder and your bond is set very high, you're going to have a much longer jail stay on average than somebody who's charged with a driving while suspended case and has a couple $100 in bond.
Well, I think this data doesn't show, data doesn't show who's in the jail total and what they're charged with. So that data may be out there. I know it's out there. I'm sure it's out there, but this data doesn't show that.
So I think one of the things that's helpful was there were point in time counts done several years ago that I think, on multiple occasions gave a good picture over time of who was in the jail and what their underlying charges were. And as I listen to this, I've got two questions. The first question is there a way to sort of elevate and get a little bit more precise with what the underlying charges are, and how many of them are misdemeanors, how many of them are felonies? The other question I have is, to what degree, Mike, do we have any comparison data since we started implementing some of these procedures to, call people, and whether or not that has had any impact over time on people's appearance rates? Is that a question that makes sense or is relevant here?
I can just make one. Oh, go ahead.
Oh, I was just going to say, looking at the state data, which will include just the 7th Judicial District, so this excludes municipal court. In 2019, 665 felonies were filed and 470 misdemeanors were filed. And that data does not include DUIs, because DUIs are listed as traffic offenses. But go ahead, Matt. I know you've done time counts.
I was going to just make a point about your first question, Bob. Unfortunately, in the Spillman system, it doesn't show what the actual underlying offense is for FTAs. You have to sort of look those up by hand in the full court system, which has the court's data. I mean, you can tell if it was a traffic case or a criminal case, and if it was municipal court or district court, but unfortunately, it's a little bit tricky to come up with the originating offense for a large number of cases. And we can certainly look those up by hand, but it just takes a little bit more time.
Well, and it's easier to say on the type of case with municipal court. So with municipal court criminal case, that's municipal court's either an infraction or a misdemeanor. So you can narrow it down that way. But then with the district court cases, there's a little bit more variation. One other thing that I think is important from the data is that it's showing that 9% of failure to appear bookings are out of county cases. And so those are cases we don't have anything to do with and we don't have any control over. So somebody has failed to appear in another county, and a judge in another county set a bond, and then they get arrested in Douglas County. So it's important, I think, to see that there's a decent chunk of these that don't have anything to do with Douglas County.
Well, another interesting thing to look at on that distribution of bookings is the amount of overlap there is between district court and municipal court for the same people. A large percentage of the people who were booked in, obviously, on multiple cases and being held for multiple failures to appear in different jurisdictions.
And when you look at that mean number of offenses for failures to appear, I think it's 1.5. So Matt, correct me if I'm wrong here, but I think that means that half of the people booked on failure to appear only have failed to appear in like 2 cases. So there's multiple cases people are failing to appear on. Is that right, Matt?
Yeah, that's right. And, if the mean is 1.5, it could mean you also have a large number of people with lots of FTAs and then a bunch with 1. So it doesn't necessarily have to be like half with 2 and half with 1. But it does mean that more often than not, people, more than about half the time, have multiple FTAs if they're in that FTA only category. Yes.
You know what the median is?
I think it's 1, but I'd have to double check that. Let's assume it's 1 for now.
Is there a statute or guidance as far as the OR bond? And I ask because it seems like we have a large or a good number of bookings there, and half the time when that occurs, they're actually out of jail before the police officer is. So I wonder if there's a way to do that on the street, since we're just issuing the bond and they're going right back on the street anyway, instead of booking someone to jail.
Sure, at one point the police department had a booking station, didn't they?
Yeah, we did. It didn't work very well. So that stopped happening. We weren't able to use it all. It took 3 or 4 times as long.
Yeah, I know you don't have it anymore because we're using it for fingerprints here in municipal court, but the answer is, yeah, there's a different way to handle that. You could actually write bonds without someone ever hitting jail. Now the number, because I got the individual number sent to me, the number of hours or percent of days that people spend in jail getting booked on an OR bond and then released, the median for that Matt sent to me was 0.2. So they're in jail for a couple hours and then being released on those OR bonds. So they're counting as bookings, but they're not, as far as an intensity of jail stay, not very high.
Wouldn't the difficulty be with having to establish the next court hearing when you release somebody in OR? If you were trying to do that from a booking station, don't you have to establish the next hearing date? You don't?
No, there's no problem with that. It's the same thing as releasing someone on a citation. There has to be a court date attached to it. You just have protocols for setting court dates.
So, and then back to my second question, has there been any summary or analysis done of the efforts that have been made to have automated calls and whether that's had any impact over time on reducing the number of failure to appear cases?
I have 2 years of live call data because we've been doing it for 2 years. The last time I looked at it, it was reducing failure to appear rates by most of the dockets by maybe 5%, except on probation violation dockets, it actually was about the same or may have gone up a little bit based upon calls.
Yeah, I wonder if Mike or Pam or somebody could give just a brief summary of what happens to let people know about their court dates, some of those programs that are newer about how to give people information about that.
We have a pretrial software called CE Pretrial, and it pulls the information from full court on everybody in pretrial status in district court. And it makes phone reminders the day before and the day of the court hearing. The only way to do text messaging, we would have liked to do text messaging, but we don't have, the only clients we manage are the ones that pretrial has assigned. There's 205. In those cases, we could mark out if they have text capability, but for the hundreds of people we don't supervise, there would be no way for us to do that. So most of the folks in pretrial status are receiving phone call reminders. And we don't know what the effectiveness is because there's really no tie back to full court to tell us. We can probably get with CE Pretrial, at least get a report on how many calls we made. It's a lot. But whether or not those folks are receiving the call and actually getting the messages, I don't know. It's just kind of a glitch between two systems that doesn't work as ideally as you would like.
On the live call data that we have, we're not using the same system as district court. We do live calls and we also do text reminders now. We break it down between people we actually have contact with personally, between contacting someone in the household to leave a message with and to leave a message. And the interesting thing is that if you actually contact the person, personally, the failure to appear rate's almost nil. Whereas if you leave a message, the failure to appear rate goes up significantly if it's with a person, and monumentally if you just leave a message or are unable to contact someone. Part of the problem is the front end, getting good contact information and maintaining good contact information throughout the process. Because if you don't have a good number, and some people switch numbers pretty often because they use prepaid phones, or some people, use phones that they don't fund every month, or their voicemail boxes are full and they never check them, or a variety of things can get in the way. But unless you make a dedicated effort to getting good contact information and maintaining that all the way through the process, you're going to lose people. So I think as far as things that we could do to reduce failures to appear, a group effort to try to get and maintain contact information would be some time that would be well invested.
Yeah, I would agree. Phone
I'm
information.
going to take oh, sorry, go ahead, Pam.
No, I was just going to say, I agree with Judge Miller. It's oftentimes the contact information is not accurate. Go ahead, Mike.
So I was hoping to transition this conversation to do a little brainstorming about solutions. And so since Judge Miller has really hit on that, I thought maybe we could do this as a group. Just throw out some possible solutions. And so, you know, one of the things is anecdotally, I've been told that it appears that the contact information in Spillman, which these systems are running out of, or even full court, that it's only about 50% accurate. And so obviously if you can only contact 50% of the people who have court dates, that's going to cut your opportunity for success rate in half immediately. So that's one area where we could look to partner together to make some improvements. And that specifically would be, you know, just asking law enforcement officers to double check or explain why they're asking for that information at the scene. Would also be when they're issuing tickets. It would also be for jail booking to kind of reiterate, hey, we will give you a notification to remind you to appear in court. Want to make sure this information is correct. But given that, I did, when I sent things out on Friday, kind of suggested to the group that you spend your entire holiday weekend researching opportunities for improving failure to appear. And I'm sure you all did that while eating hot dogs and apple pie and watching baseball. But anybody have any other ideas for things that we could look at to this? And I see Shay has raised her hand, so go ahead, Shay.
Been helpful, at least in municipal court, is the add-on docket. And I know that the district court has recently been posting hearings, which I think is helpful. But one of the things I think maybe we should start considering is a way for a person, if they have missed their court date, to get added back onto a docket or get back in front of the court without being arrested. Right now, it's kind of hard to figure out. Each division has their own sort of separate way of doing it in district court, and is trying to, if your client has missed it, it's kind of hard to otherwise get back in front of the judge other than turning yourself in on a warrant, being arrested, and that's a hard thing for people to do. And I will tell you, getting more information from the law enforcement on, you know, contact information, that's not just to them. It's really hard, even for us. Once we get appointed, we'll get information, and it just, people have a hard time maintaining the same phone number and or address throughout the pendency of a case, which may take a significant period of time. So that's not universal to them, but if there's some central way for a person, if I can tell every one of my clients, you need to go to this place and see when your next court date is, or if you have missed it, you need to appear on this day and get back on the court's docket, that may help.
To give you some indication, numbers wise, of the amount of warrants bookings that were potentially saved by an add-on docket during the same study period, because we have one every day, we lifted between 5,500 and 6,000 warrants, because when I looked at the study period, I had the data pooled. So that's 5,500 to 6,000 warrants that never resulted in any jail time at all.
What was the date range for that, Judge? Just curious.
You're saying study period between
that 3.5 years that Dr.
Yeah.
Craven's pulled.
Right, because I wanted to know how many warrants didn't get served, and I can find out the exact number. It's in my email here, but it's between 5,500 and 6,000 warrants during the 2017 to, I guess the study period was January 1st, 2017 through through July 1st of 2020, correct?
Yes.
Hold on, I'll look.
Oh, yeah, I used July 15th, but July 1st is really close.
And,
But
can you restate that? Because I guess I'm confused. So those are 5,500 to 6,000 warrants that were never never served, but they're in the data set we have in front of us?
No, they're not in the data set. What I'm saying is that having the opportunity for someone to appear and address a warrant's pretty useful. During that same time that we had all the people who were arrested, we had a lot of people who subsequently appeared and did not get arrested. They had their warrants lifted and were given a new court date that way. Some places call them second chance dockets, and you know, it's not a new concept for municipal court here. Predated my term as a judge, and you know, I think it's just generally something that has happened more traditionally in municipal courts. I know there are a lot of other ones in the state that do them.
Well, and you know, two things on that. One is, as Shay pointed out, that sort of happens informally, or not informally, but in a less systematic way in district court. I think where the attorney calls the judge's office and gets the person back on a docket, or so that definitely happens, but there isn't a specific docket for it. But the other thing to keep in mind is that that's where the seriousness of the charge also plays a role. So if it can be appropriate for somebody who doesn't show up for their speeding ticket to just show back up on another docket and get to court that way. But somebody who may be charged with a felony, that's more of a gray area whether or not it's appropriate for them to not come to court and then just be able to show back up at a different time. So I think those are some considerations to think about.
Yeah, I agree. And not every warrant that people come and talk to me about is lifted. The majority are, but sometimes they aren't. You know, if somebody's had a ton of warrants and new charges and other problems, sometimes those warrants aren't lifted. I'm not trying to say it's a automatic change.
Sure.
I'm curious, now that we're doing a lot of video court, I mean, from the judge's perspective, has that been better for failure to appear? Are you having less of that, or is it about the same as usual?
I don't know. Judge McCabery, what do you think?
I think I haven't been doing criminal court since we've had video appearances, but the general feedback that I've gotten has been positive, that it helps reduce. So, but I don't have any personal experience with that, and I don't have any way to quantify it for you.
Is that a possibility after COVID? You know, assuming we get out of COVID.
I mean, I'm one. Yeah, there's certain offenses for which I would not think it appropriate, but for certainly the majority of offenses, my view would be video court should be should very much be an option for folks. Now, there's, you know, Shay can jump in. I think that there's practical challenges that arise for defense counsel that are different for video court than personal appearances, and there's
Judge, I'd agree. One of the things that we've just been talking about is when you don't have consistent contact information. So for instance, your client may be given a court date, and then a couple of days before the hearing, we'll get the Zoom information for how they're supposed to appear by Zoom. Well, the phone number I had no longer is working, or they don't have an email address, or I have to mail that to them at their last known address, which is usually a family member, not really necessarily where they're living. So that makes it more complicated. But and then you'll get people who fail to appear and that sort of stuff. But for the most part, I think it's been very helpful to be able to just say, hey, you just need to appear for however long your docket is. You can do that from wherever you are and not have to make travel arrangements and have a bunch of people sitting around the courthouse. So I think I'm hoping it continues.
Could I actually ask a question? And I'm sorry, this is going to roll us back to, but I wanted to ask for some clarification on Shay's point about the add-on docket or the second chance docket. Is the add-on docket, judges, that already exists? Yes. And how often does an add-on docket roll through, or does it not exist already? I guess I'm asking, and that's part of it.
If you're asking what I was referring to, if you miss a date in municipal court, you can show, I'm sorry, yes, in municipal court, you can show up at 8 a.m. and and ask to be added onto that the court's morning docket.
Okay.
So if I have a client who missed their court date, they can show up at 8 a.m. and ask the court to take up their case that morning. And then they can ask the court to recall whatever warrant, if there was a warrant for their failure to appear.
Okay.
And then Judge Miller can decide, yes, based on the reasons you didn't appear, that's appropriate, or no, I'm not going to lift that. You need to turn yourself in on the warrant and get booked back into the jail.
Okay.
In district court, if I have a client who doesn't appear, the court will often say, I'm going to issue a warrant, but not today. I'll issue it on this date. So if you can get in contact with your client and have them show up, then this is what we'll do. What I was suggesting is that because municipal court has a very set procedure, I can tell any client who fails to appear, this is what you need to do. That's not the same with district court. So if we had something that either there was a place where they could go to actually check their court date, which I think the district court is trying to do, or there was a more uniform process for addressing it, I was just suggesting that might be an option. And again, every case is going to be different. If you fail to appear for your sentencing, and it's expected that you were going to go to KDOC, the judge may not wish to lift that warrant. You may have to actually appear so that we know that you'll show up.
Absolutely. Thank you for that, because now I can see the not only the usefulness of what you're talking about, but kind of like the world it's existing in. And I guess maybe then my question is maybe for you, Shay, are you imagining, does it make more sense for something like that to be housed in a physical place? Does it make more sense for it to be online in terms of like how to get that mechanism in place for folks who have those warrants?
What I had sort of been thinking about in my head is there should be a place online where you can go in and check and see when your next court date is, right? So if you have clients who do not necessarily have access to the resources we have, where I can just jump online and see, they could go to the library at any time or whatever, get online, check their case and see when they're supposed to appear. And then if you have a regular add-on docket, I can say, you didn't appear, you need to either turn yourself in on a warrant or you need to show up on this date at this time, which is an add-on docket, and ask the court to take up your case.
I just want to, as just random community member, to me, I like to thumbs up that idea because it allows, particularly for folks who have understanding of anxiety and the access issues that we're talking about, particularly where we started with this question of information. When that information gets slippery, there's still like a basic piece of information that legal representation can hand out to clients and say, go. I think that's a really good thing. That's my 2 cents.
And I'll reiterate, we've seen a fair amount of what Darren and Shay are talking about. When providing case management out of the jail, we would always check before we met with a client in the community to see if there was an active warrant. And almost every time that we noticed one and we contacted the client wasn't aware that they had an active warrant. And it was nice with municipal court to be able to say, hey, you can show up any morning at 8 o'clock and get this taken care of. And also I know the jail does that for people scheduling visits, that if they have an active warrant, they will, if it's not for a serious charge, they will call them and say, hey, you need to get your warrant taken care of before you come to the jail for a visit. So in improving that opportunity, access, all those issues around that seem to make a lot of sense.
Mike, I would be curious also if there are ways to build on what's being done with video appearances, and if you think of it from the standpoint of the defendant or the person who needs to appear. If somebody, I think of it through the mental health lens. So if somebody is cognitively impaired because of a mental illness, if somebody's compromised by the fact that they're homeless, if somebody is unemployment, status, transportation, all the things that conspire against a person's ability to sort of navigate through a day. If there were some community-based tools, Shay was talking about maybe being able to check in at the library or an alternative location or virtually, what could we do on the front end to offer some more opportunity to, without some of the overarching things that can be really, really challenging to somebody who, like I said, is cognitively impaired because of a mental illness, requires supports to get from point A to point B. There might be some technology things and IT things that we can do if the video court appearance is working and is a viable option and is a useful tool. How do you design the system? How do you design that mechanism so that there are multiple, should there be a camera and a workstation at the Lawrence Community Shelter or the Community Mental Health Center, which might be an environment that's easier to step into or more likely to get somebody to comply with a court appearance.
I was going to say on that note, Bob, a lot of the behavioral health clients that participate in court at Burt Nash, they go to Burt Nash to attend the hearing. So we're doing a little bit of that. And we do have some probationers who come to the probation office to attend hearings. So we try and accommodate or at least help people attend. I know that I've heard other jurisdictions have something called an amnesty day, and I'm not sure what that all entails. Is that different than having the add-on docket?
Similar concept.
Is it similar? Okay.
I'll just say I like the idea of that, and Shay can tell me if I have a bad perception, but I feel like Division 4 was, and I can only speak to Division 4 when we were doing criminal dockets. I felt like anytime somebody told me that they wanted me to hold a warrant or to give them a date to show up, that we would do it. The hard part is you have, municipal court, one judge, he's familiar with anybody who could show up at 8 o'clock. We can't have just a single day because we would have people showing up on cases that a judge may know nothing about. And so there's layers to it, but conceptually, I think the idea has tremendous merit. It's just, and I appreciate Pam mentioning, I thought BHC, and that I knew some people were making appearances from probation office. So, we're doing that to that degree. And it's an idea that I think the judges should discuss in terms of a way to maybe make it more formal and a little more streamlined. But there's always that balance of a certain level of formality helps the process work. So just a lot of things to balance.
This is Sarah, and I guess I brainstorm and maybe take it a slightly different direction, and I guess I have some clarifying questions too. So, I remember several years ago when we talked about pretrial services, looking at the folks that were in the jail because they were unable to, that when they're in defense, even if they were convicted, would not result in jail time. Mike, there's a better way to say that than what I just said. But I think that, I wonder if we can use a similar lens to the issue with municipal court. There's high cash bond, there's a high number of cash bonds associated with those folks that are that are booked into the jail. Is that working? Is this, and while I understand they're in and out pretty quickly, it does represent a pretty substantial base of our jail. And when we look at who needs to be in jail for what purpose, is there more to explore there as a different, as a maybe a different strategy than just you're in jail and you got to pay?
Well,
Does that make sense?
I can give you a little information about why things work the way they work. Because everyone's released previously under either an OR bond or under just a release, a lesser restriction. Someone just signs a citation and is released at that point. At that point, issuing a warrant for another OR bond that they've just violated an OR bond on doesn't make a whole lot of sense. So the next step is cash or surety. The question is, why cash as opposed to cash or surety? The answer is because cash bonds, when set in a low amount or security deposit and the money is available to be returned, cash or surety bonds are essentially a fee that's added for most people who post things with a surety. So that's money they're never getting back. So I have the option of using a cash or surety bond in that situation, but I use cash bonds because the money's available. If they're found not guilty, they get all their money back. Now, if the question is, should we issue warrants for certain charges at all? The answer to that is I have an obligation to proceed with a process for all the charges that are made illegal. That isn't my option. I don't get to decide as a judge which charges shouldn't be pursued. No one rationally, if they know that there's no possibility of any sort of consequence, is ever going to want to attend something that has the possibility of depriving them of their property in the form of fines and fees, or their liberty in the form of jail time. No one rationally is going to want to do that, or few people rationally are going to want to do that on a completely voluntary basis, I assume. So if someone's already failed to appear and you don't issue a warrant, the question is, why have the law in the first place? If it isn't that important, then why make it illegal?
I appreciate that, Judge Miller. I guess I'm just trying to brainstorm ideas of where we could go from here. I know that we've had different success with pretrial release program, different types of pretrial release programs. And so that, is there somewhere between having them sit in jail till they have the cash and no,
they don't.
What?
They don't sit in jail by and large until they have the cash. That's the misunderstanding. If you look at the amount of jail time on that data set, it's 0.8 days. They're not sitting in jail until they have the cash to post, because immediately on the next day they're seeing a judge. Whether it's in district court or municipal court, there's an obligation immediately to have bond reviewed in the case to be moved forward.
One thing I'll say is I think, Judge Miller, didn't we find out that people stay longer in jail if they have higher cash bond amounts?
I imagine they stay higher in jail if they have higher cash or cash and surety bond amount. The thing is, you're making a big distinction between cash or surety, but both of those are money bonds. And I don't particularly like money bond. As a philosophical concept, there are many states that have moved away from it, but there's no distinction between cash or cash surety in terms of what someone has to do, which is dig in their pocket for money. The distinction, depending on where you set the bond amount, is whether they get that money back at the end of things or whether it's a fee that is just gone, whether they're found guilty or not guilty, whether they owe fines or anything else, that money's just gone once it's posted. It's basically like buying a ticket out of jail versus a security deposit. So I don't have any problem focusing on money bond if we want to talk about money bond, but money bond equals not only cash bonds, but cash or surety bonds as well.
I want to hold on to that conversation, take it a step back though, is I think our focus should be to eliminate that initial failure to appear. So we don't need to give OR bonds on people failing on OR bonds. We want to keep people on the OR bonds from failing to begin with. And I think, Judge Miller, and you probably could identify 10 off the top of your head. There's probably people who come to municipal court on a regular basis who you know when you issue that next court date, due to some of the struggles in their lifestyle, that they're going to struggle to appear. And but you have to issue that date. And so in those situations, pretrial release could be an extra support for those individuals to assure their appearance.
Oh, I have no problem with the idea of pretrial release. The problem when we talked about it initially, when we were talking about it at the incarcerations committee or alternatives to incarceration subcommittee, the problem is there just aren't very many people that would be released for very many days in that circumstance. The standing jail population for municipal court was less than 20 people last year, if I remember correctly, that weren't being held in district court. I'm in no way saying that we can't improve. We certainly can improve, but if we're going to invest money in a pretrial release program, I think it has to be something that will show a significant effect. And because most everyone's getting released initially, and then after the fact that when they're arrested on warrants, they're not staying a particularly long time. What are you doing in that situation with pretrial release? Now, there's some other benefits to a pretrial release program that aren't quantifiable that way. One thing that's a benefit to a pretrial release program is it reduces the incentive for somebody to enter a plea just to get out of jail. And that's an important thing to consider, because people shouldn't be entering pleas on something they would otherwise fight just to get out of jail, because they think that that would get them released after the case is over. So there's some other non-tangible ideas that are benefited by that, or less tangible ideas that don't go to dollars and cents and jail days and amount of days. But I don't think in municipal court, unless you expanded pretrial release to include people who had appeared or had failed to appear on multiple occasions, I don't think you're going to get a big number impact in that situation.
Darren, did you have a question? Oh, you're on mute, Darren.
Sorry, yeah, I'm a little bit worried about derailing with this question, but I am curious, Judge Miller, you brought up moving away from money bonds and that other places have. What are the other options?
The federal system is the model that's used by a lot of different states. It's a detention or detention with conditions system where the judge makes an initial decision about whether someone should be held without the possibility of posting bail, or whether bail should be released with various conditions and various monitoring that's involved. It's similar to pretrial monitoring. Federal statute, for example, says that no one should be held in jail only because they can't post money. And there are a lot of states that have jumped. Well, I mean, it's not a new idea. Bail reform regarding money bond was going on in the 60s. So a lot of states have modified their statutory or constitutional frameworks in order to apply a system like that. There was just a draft report that was released. I don't know whether it's been released in public yet or not. On there's a committee, a Supreme Court committee that's been working on this issue. So they're going to have some recommendations on this issue as well. I'm not going to go into those recommendations because I'm not sure they're public at this point, but it's an issue. It's a national issue. It's not just a local issue here.
Yeah, I mean, I will say, just as a random student of history, I do know that, yeah, the question around doing away with bonding in that way, or bond reform certainly is decades old at this point. But I mean, I do find myself compelled and really concerned about how money plays into that. And I know, as I said, I'm a little bit worried about derailing sort of the brainstorming portion of this, but I think that that's always something, that question of equity and access is threaded through a lot of what we're talking about. And to Judge Miller's point about sort of the impulses and the ways that we incentivize just handling some of these warrants, I do think it's all part of a network.
I have a question. Is electronic monitoring only used as a part of sentencing, or is it possible that that could be used as a part of monitoring someone who's had more than one failure to appear?
Tamara, let me talk to you a little bit about electronic monitoring. We have, of the pretrial clients, currently we have 205. 66 of those are on electronic monitoring due to the nature of their crime or other issues. We also have 25 people that are strictly on house arrest. So yes, it can be used in a variety of ways.
Is it very expensive? Is it more expensive to use that mechanism with a person who's had failure to appear? So,
well, it's a lot cheaper than jail.
okay. So why is that? Is there an argument for not doing that?
No, we are doing it. And the cost is not given to the defendant.
Client doesn't pay.
Yeah, we're not charging for pretrial. We're not charging defense. I think Pam said 66 out of 205 people on pretrial release are on electronic monitors, so about 33%.
So has that helped with the failure to appear situation?
I don't know. We have data to say that one way or the other.
And we're doing it we're doing it for district court, not correct. Only.
Correct.
That's something we can look into from a data standpoint.
I've regularly used house arrest as a condition of bond before on failures to appear. So we don't have a formal program, but it's happened a few times.
And we have a decision-making grid that helps us determine when that's appropriate to be used pre-trial. So it's not just made on a whim; it's made on data and a matrix. So I just want to cover go back to one more piece while we have the chiefs and we have Captain Simmons and Under Sheriff Buckholz out at the jail. Is this improving contact for people with improving people's contact information when they're released on bond. Chiefs or Sheriff's Office, any suggestions on that? Like I said, anecdotally, we think that's only about 50% accurate, and opportunities to improve that, or anything we can look into.
Their phone number is typically the one that they give us the time of booking, so it's just part of the process of filling out the form. So there's no way to verify that. Their cell phone is off by the time they're in the jail. So typically it's just the telephone number that we're asking them for.
Nice. So there's Under Sheriff.
Yeah, I'd reiterate that we're really relying upon what the individual tells us with no way of verifying it on the phone number information.
Charles put some information in the chat box about the task force report with the connection to the website.
Thank you, Charles.
I just want to publicly announce the numbers I put in the chat box because I don't want to have an open meetings violation. The actual numbers from district were from municipal court were 5911 were the lifted warrants, and Tamara had asked how many warrants total were issued, and it was 10,772.
So that is more than half were dismissed.
Yeah, we call it lifted.
Okay, sorry.
No, dismissed is typically used for the case itself. Yeah, that's about half or a little more than half.
Okay. Thank you.
All right, so I'm going to let us jump to the next topic, but just to summarize this, if people have ideas, please email me or Pam, and we'll add these to the list. But also, my plan is to have the Incarceration Alternatives Research Work Group to take this list and start seeing if there's pieces we can look at. That will also require us to maybe add some different players to that work group. So we'll update you on that as well. And I think we have some data points that Dr. Cravens and hopefully Judge Simpson can continue to drill down on with that. So Pam, I'll turn it over to you.
Great. I think our next person is Mayor Ananda. Did you want to talk about the implicit bias training or rescheduling that?
Well, as we all know, we rescheduled that, or we canceled the existing date for that training. I know that that was a high priority for this group. I also know that things are pretty in flux and pretty unknowable for the next few weeks at the very least. And so I wanted to check in with folks. I think we as a group wanted to check in with folks. Mike, correct me if I'm wrong. She did indicate that she would be able to do that via Zoom. Is that correct? Okay,
Yes.
So we have that. We have that option if we want to schedule that. We also have the option of scheduling it in person. I think that it's going to be harder to set a date for that right now, given the reasons that we chose to hold off on doing this anyway. And so I think getting some feedback from the group would be helpful.
I guess I would say that, you know, when we discussed this earlier, we talked about the value of really doing it in person and and just the worries about how effective a Zoom conversation would be. So I just want to see what the group thinks about that. I guess I just want to honor that.
Well, I still believe that we should try to do it in person whenever we do it. That interpersonal dynamic is extremely important.
So, I mean,
go ahead.
I hear that. I'm sort of wondering what, and understanding the Mayor Nada has already laid out that it's hard to tell. And at this point, I'm sort of wondering what that really practically kind of looks like. Because I hear the point about, you know, the will of the group was in person, but that may mean we're really talking about after the start of the year, 2021. Do we feel okay saying we're going to continue the work of CJCC without having that training before first of a new question?
I think that's kind of the heart of the conversation, Darren. So thank you for saying that.
I would reiterate Darren's question is, I've had multiple employees and other agency employees who have contacted me wanting to participate in this training. And I think that was my original thought was the CJCC would go through the training, then we would offer the training to our employees multiple times over the next year. And if we are going to delay because we want to do the training in person, does that mean we should delay the training for the employees who could do the training by Zoom?
I will say, for whatever it is worth, I think I'm in the camp. No, I am in the sooner is better than later camp. And the reason is, I will just say from my own experience at not only at KU and other places, when we talk about things like implicit bias, when we talk about things that have to do with equity and inclusion, because they do get squidgy, they become very easy to be a can that gets kicked down the road. And I'm not saying that that's necessarily what the intent, but it is sort of the impact. So I hope I'm not cutting off further conversation. I just want to lay that out there as sort of where my place is.
I agree with what you're saying, Darren, and I would say that unfortunately, via Zoom or other virtual mechanisms, it's easier to tune out.
I do hear you on that, definitely.
I also think that we have to look at what is perfection versus what is effective. And I've been in some very effective Zoom trainings, conversations, dialogues, particularly when breakout groups have been used effectively. And I've been in ones that I've been able to ignore. And I think we're all probably guilty of that. But I also get from this group a strong commitment to engaging in this conversation and this topic. And I trust the integrity of the folks in this group to engage that to the extent that we can via Zoom, acknowledging, you know, that isn't the ideal solution for any of us, but putting this off is less ideal than the semi-ideal version.
I guess I'd say too that if that's the case, if we go with Zoom, it sounds like this provider doesn't have a lot of experience with that. So I guess that's one of the things I would be concerned about is, do we need to find a different provider or does anybody have experience with the type of training that has been done very effectively over Zoom? And I know Craig put in the chat about after the vaccine. I feel like that's probably far enough down the road that we can't wait that long. From what I'm hearing from the group, but maybe there's some sort of follow-up. We could do a Zoom and then a follow-up, but at a later date. I'm not holding my breath for a vaccine that we're all going to want to take in the near future. So
I think if we do it, end up doing it initially through Zoom, that we should have a follow-up in person at some point.
And Sarah, I did the training through KLC, a coaching one, which was a very intense, and actually it continues to go. And that was 100% Zoom, and it was very effective. It did allow for a lot of deep conversation and work during the time. What it did include, or what it involved, was having a person who was dedicated for managing the Zoom piece while the presenters did their piece. And so, I think we can do it via Zoom. Whoever does it probably needs an assistant who's well-versed in Zoom, and it could be a volunteer, but who would just manage that part of the event.
I don't understand why we would even consider this to be a one-off training. The idea that somehow we do one training and we're suddenly inoculated against any problems that we've had just doesn't make any sense to me. So if we want to do it with Zoom, like Craig and Sarah suggested first, and then follow up, I would imagine as we have more onboarding, because this council has a history of adding and losing members over time, we'll probably want to revisit this anyway. I don't see any reason to avoid doing this work as soon as we can, and then revisiting it in a year when we can do this in person, hopefully.
I would add that I agree with Patrick. There needs to be somebody in the background, and we have some folks that have been doing that for not only local conferences, but some state, and we've been asked to do it for national conferences. So we have some folks that could do the back end producing of Zoom if that's something that you would like to use.
So
I
is
think
there,
the Zoom question is, what's our ambition in terms of depth? I think we need to, if we're going to go online, then I think we need to be realistic on what we ask of people and what we ask in terms of setting an agenda. So, we're not going to be able to accomplish online through a Zoom training what we would by spending half a day in a room together. So, defining kind of what the expectations and the aspiration is, I think is important. And the facilitation is key. So if this training company doesn't have a lot of experience facilitating Zoom, we should look for somebody who does, because at the end of the day, it's taking up people's time, and we want to do that in a way that matters.
so I'm hearing some consensus around doing this via Zoom. Well, not ideal, and then having some sort of in-person follow-up at some point. And then as far as capacity, I think that Mike, you can perhaps talk to the organizer for that and see what that capacity looks like and whether or not that's realistic. And then we could bring it back to this group for some dates or an email with some dates.
Yeah, I know she was prepared to offer this by Zoom on the day we had scheduled, August 29th. And she's now offering this training with Ogden, Utah by Zoom for all of their employees. And these are the dates that she gave us. I can create a dual poll and send that out. I guess my only question is I'm not sure how to determine if her Zoom experience is enough for us or not. I do like Lori's offer of having some additional technical support to allow her to just be the facilitator and someone else to run the mechanics. That makes sense.
This is a little bit Machiavellian. I mean, do we know the date of the Ogden?
Well, I could find out. I bet if someone was willing to participate, I think Loretta would probably let one of us sit in on that. Is that your suggestion?
Suggesting that might be one way, or even if we're. I mean, part of it is I hear the concern about the usefulness of Zoom. I do find that a lot of it helps if someone can, as has been suggested, just focus on what their expertise is, engaging us, and if someone else is handling making sure that the proper slides are up, that it's moving, that people are, that someone is monitoring the chat and is able to jump in and say or whatever the breakout rooms. That if there is a guru that handles that, the facilitators normally are able to lean into their expertise pretty well. So I do offer that as something that if we feel that she had the expertise that we needed before, that expertise isn't going away because Zoom. It's making sure that there's the support there.
And it sounds like we do have that support with Lori's offer, which again, I've attended some of their trainings, and again, it's been very seamless on the Zoom part of it for the content to be focused on by the presenter and the participants. So I think we do have that if we want to move forward with it.
So I've been through a number of these trainings, and while I'm always a person that likes to do things in person, I don't see a reason why it can't be done through Zoom. Other than I would ask this, is this an open meeting? Because the value in a lot of these trainings is the ability to open up and have a discussion and to give perspective. So while I do think that we can still get from it, I don't know that you're necessarily going to have every person willing to open up to what could be a public meeting.
So, Chief, in that regard, and we have legal counsel review this, and I sent information to the district attorney and to Shay about it. It can stay a closed meeting if and only if there is no discussion of any work involving the CJCC. So Mike and I discussed this, and we thought this actually presented a very good challenge to this group to not to not deflect issues about, well, let's assign that to a work group and have them work on it. That this would need to be about individuals' personal and professional experiences, not about the work of CJCC, jail, law enforcement contact, any of those kinds of things. We would need to avoid that. Just talk about the work of us as individuals and our experience. Does that make sense to everybody, the distinction between the two?
Yes.
Yes, 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 yes.
And along Chief's lines and a little bit to Bob's point, I guess I would just verify with Mike that it would still be a full 8-hour training with all the breakouts, or if we're looking to do something that might be more introductory in the first phase, and then, you know, when we can eventually meet in person, maybe it's a little less, there could be more discussion. And I would say that, like, the hard part too, that, and someone, and Commissioner DeRusso mentioned this in the chat, the hard part about making it private is that, you know, any one of you on a Zoom call can record your Zoom recording. So that could be shared, which I think could make some people nervous about participating. So we would, you know, need to have some really good ground rules about those expectations for communication and so forth.
Actually, Sarah, that's one of the things a producer can do. They can lock down the ability to video, except for the host, and they actually would have to ask permission to video. So that might be a way to kind of help, you know what I'm saying, build that comfort if the group is so.
I think they were just worried about, like, putting your phone up to the microphone and recording.
Yeah.
Non-Zoom related stuff.
Yeah, actual Zoom recordings we could control. Yes, you're right. Can't control that.
And that can happen in person as well. I mean, I can have my right next to me and that can still occur. So.
All right, and we're losing participants as we go over the time limit here. So I will email or send out a doodle poll for these dates. Please reply as soon as possible, and we'll get that scheduled. And I'll work with Lori on her offer for the producer role from DECA.
That sounds great. Thanks, Mike. And then
that might affect the dates. You might want to run those. Let me run those by my staff for availability before you confirm, just so that we know we have production.
Okay, I will send them to you first, Lori, before I send out a doodle poll.
Okay. I just want to make sure that you don't get a date set and then we say, don't have anybody.
That sounds great. Thanks, Lori. Do we want to schedule an October meeting date? That's the next question. It would normally be on October 13th if we do it. Otherwise, our next meeting wouldn't be till November 10th. Does anybody have any strong feelings about that?
And I'll just say I have 2 work groups ready with presentations for you guys. And we've got other hot button issues we're working on. So I'm pleading for more of your time.
I would suggest that we do go ahead and meet if the group is willing. But I guess I'd like to hear from other members. It does feel like we've got a lot of pressing issues that we need to keep making forward momentum on.
If we're looking at the 13th, and I'm not sure my calendar is exactly current, but we have trauma-informed training with the DA's office virtually. A lot of the chiefs do, the sheriff will, those kinds of things. Unless if Charles is still on here, can confirm that's still a good date.
Yeah, those dates are still solid.
Okay, then several of us will be busy all morning and part of the afternoon with trauma-informed training through the DA's office.
Well, we definitely don't want to have it while you're not able to participate. That wouldn't be helpful.
But how about the 20th? Thumbs up from the mayor, Darren.
Yep.
Judge is not saying no, so that's a good thing. I'll go ahead and schedule it for the 20th, send a meeting invite out to everyone.
Okay, that sounds great. Do we have anything else we need to discuss for the good of the order? Seeing none, I think this meeting is adjourned. Thank you for all.
Thanks, everyone.